Hey folks, James Abrinio coming to you from Abrinio Cho, your Northern Virginia personal injury and criminal defense law firm. I will tell you over the coming months, you will also be seeing, as my firm has always handled medical malpractice cases, we are going to start handling a bit more. We'll likely be partnering up with a good friend of mine, Lee Livingston, as well as his firm, the Livingston Law Group out of Charlottesville, and handle a decent amount of medical malpractice cases here in Northern Virginia, Fairfax, Arlington, Loudoun, Prince William, Alexandria. And so, with that in mind, going forward, I will be sharing a bit more information about medical malpractice claims. Medical malpractice, if you don't know, is really kind of a subspecialty of personal injury. And it really means that you are injured due to a doctor or another medical professional falling below the standard of care and causing your injury. They're very complicated, complex cases. They can be expensive to litigate, and they are very strongly fought by medical professionals who want to do everything they can to avoid liability in these cases for insurance reasons, and also just the fact that they, are defensive of their work, which as a professional, I can understand that. But when we represent victims, our job is to do our best to represent them to the fullest extent that we can. One video that I wanted to do, because I get this question a lot. I have folks that tragically call me. They have a loved one who's recently passed away, and they are concerned that medical malpractice was the reason that their loved one passed away. And I asked them, did they get an autopsy done? And they say different types of things, but a lot of times they say, well, I don't know if one was done, not sure if one was completed, not sure if the prosecutors or government are going to do it. And that usually tells me that one was not done, because either, if it's in Virginia, either the medical examiner's office chooses to do a government funded and government sponsored autopsy for specific reasons we'll get into, or they don't. And then it is the family member's duty to get an autopsy done, or one won't be done. I mean, it's just really that straightforward. And so this video is, you think your loved one died due to a medical malpractice, should you get an autopsy? And that's really what I'm trying to address here. Quick heads up, a couple things. Number one, whenever we're shooting these videos, this is not for legal advice. I'm not your attorney until you sign on as a client. This is for informational purposes only. The goal of these videos is really just to give people information to think on. You need to speak to your own attorney in order to get specific legal advice. You can't rely on this. Secondly, we are a Virginia firm. We practice in Northern Virginia. For injury cases, we go all over the state, but our main focus is here in Northern Virginia. So when we're talking about how things work, informationally wise, we're talking about Virginia. Okay, if you're in a different state, you need to look for information about your own state. And last thing, make sure to like, subscribe, and share if you find this video useful and valuable. We're just trying to grow our scope, and that's how YouTube works. And so hopefully, if you're on YouTube learning stuff, you're trying to get others information as well. So that being said, when is an autopsy usually conducted? When somebody dies in Virginia, there will be, in some instances, the medical examiner. You hear about them in smaller counties and in cities and towns called coroners. Virginia, we call them the medical examiner. Oftentimes, the medical examiner will investigate a case when there are unusual circumstances. It's not situations, for instance, somebody, an elderly person's in hospice and passes away naturally, not natural deaths, but when there's some concern about the cause of death. And I've listed here a couple codes, Virginia code statutes to take a look at. Virginia Code Section 32.1-283. This deals with death investigations by the chief medical examiner. Virginia Code Section 32.1-285. This deals specifically with autopsies, and I figure it would be useful to actually take a look at those statutes real quick. So with that being said, looking at Code Section 32.1-283, investigations, death, obtaining a consent to removal of organs. So just going through here, upon the death of any person of trauma, injury, violence, poisoning, accident, suicide, or suddenly when in apparent good health or when unintended by a physician or in a jail, prison, or other correctional institution or in police custody, or when at the time of his death or her death, or immediately prior to the admission to another hospital, an individual receiving services in a state hospital by the Department of Health, Behavioral Health, and we'll skip past that, suddenly or apparent result of fire, or in any suspicious, apologies, or in any suspicious, unusual, or unnatural manner of death, or the sudden death of an infant, the office of the chief medical examiner shall be notified by a physician in attendance, hospital, law enforcement officer, funeral director, or other person having knowledge of such death. So it really situations where it's unexpected, it's unusual. The chief medical examiner and medical examiner will be called in, and then they'll do a report and they'll investigate. Good faith efforts shall be made by any person or institution having initial custody of the dead body to identify and notify the next of kin of the decedent. Notification shall include informing person presumed to be the next of kin is the right identification confirmed without delay. That's just giving the family next of kin more rights. Upon being notified of his death as provided in subsection A, the office of the chief medical examiner shall take charge of the dead body, and the chief medical examiner shall cause an investigation into the cause and manner of death, and to be made a full report, which shall include written findings to be prepared. In order to facilitate the investigation, the Office of the Chief Medical Examiner is authorized to inspect and copy pertinent medical records of the decedent whose death is subject to investigation. Full directions as to the nature, character, and extent of the investigation to be made in such cases shall be furnished each medical examiner appointed. And let's see, and then this statute also goes on. Reports and findings of the Office of the Chief Medical Examiner shall be confidential and shall not under any circumstances be disclosed or made available for discovery pursuant to, shall not under any circumstances be disclosed or made available for discovery pursuant to a court subpoena or otherwise except provided by this chapter. Let's see. Copy of each report pursuant to the section shall be delivered to the appropriate attorney for the Commonwealth, appropriate law enforcement agency investigating the death. And so this statute really lays it out. Really, when you have unusual deaths, kind of more simply put, there's concern about either some homicide, some intentional or gross negligence reason for death. And just to be clear, though, when we're talking about, the standard not unusual causes of death, so even a medical malpractice, and particularly medical malpractice, those usually are not going to warrant the chief medical examiner to perform an autopsy. So unless you're concerned about a crime being committed, it's likely not going to be a situation where the government is actually getting an autopsy done. Now, that being said, let's look at the statute regarding autopsies. This is 32.1-285 autopsies. So, and just getting back to that last statute really talked about when the chief medical examiner investigates. So if there's sudden death and all those reasons, an autopsy itself even requires kind of a higher threshold. And in this statute, it really gets to it. If the opinion of the chief medical examiner, it is advisable and in the public interest that an autopsy be made part of the investigation, or if an autopsy is requested by the attorney for the Commonwealth, meaning the prosecutor, called the Commonwealth Attorney in Virginia, or by a judge of the circuit court of the county wherein such body is, or the death occurred wherein any injury contributing to or causing death was sustained, or if the decedent is an inmate in custody of the Department of Corrections. So people locked up or incarcerated are going to have autopsies. An autopsy shall be performed by the medical examiner and assistant chief medical examiner or pathology, who commissioners entered in, a pathologist entered an agreement. So the chief medical examiner, their assistants, or essentially a local coroner. They can, upon a petitioner of a member of immediate family or the spouse of the deceased in case by death by injury, such circuit court may, for good cause shown, order an autopsy after providing notice or an opportunity to be heard by the Commonwealth for the jurisdiction wherein the injury contributing to death occurred. Further, in all cases attributed to sudden infant death syndrome, autopsy shall be advisable. And in the case of child death investigation that indicates child was abused or neglected, or the child suffered from abuse and neglect, the case shall be immediately reported to the Child Protective Services. So essentially, again, really the chief medical examiner is only going to be doing autopsies when there's concern about some type of crime, or it's specifically laid out into the statute. So just keep that in mind. So if you tragically believe that a family member died due to medical negligence, negligence is not a crime in Virginia. Negligence is really just, in terms of the, specifically when we're talking about negligence of doctors or medical professionals, we're talking about when they went below the standard of care of any procedure or any treatment that they are providing. Negligence is really essentially they messed up. It's not an intentional act. It's not a gross act where they're acting with conscious disregard for safety, where they messed up. And that's what we're talking about here. And in those cases, especially medical negligence, unless there's something more, a lot of times you can expect that an autopsy won't be done. So if you have a family member, again, that you are concerned about in medical negligence, be straight up. Ask the doctor, is an autopsy going to be performed? If you're deciding how this loved one died, how are you reaching that basis? And can we get an autopsy done if one is not done? Okay. That being said, what if the government chooses not to do one? And let me back this up. Sorry. What if the government chooses not to do an autopsy? Okay. You can arrange for a private autopsy. Just to be clear, though, and what does this mean? This essentially means that you will hire what we call a forensic pathologist, somebody that studies in and knows how to do autopsies, to actually perform an autopsy on a private basis. That also means that the family usually has to retain that person, that doctor, to do that autopsy. It is not something charged to the state unless it's unusual circumstances. It is usually something that the private citizen, will have to arrange to be done. And just to be clear, the sooner you can start lining that up, the better. In some instances, folks call me, somebody has already been buried. It is possible to exhume a body to do an autopsy, but just from a common sense standing, just from how the body decays after death, common sense would tell you that those are, first of all, more expensive and more complicated. So if an autopsy can be done as soon as possible, that's really what you want. Of course, if somebody was cremated, there's not really much that can be done at that point. I mean, the body is gone. So there's not a whole lot for a doctor to do. Okay. Now, if I will say, and again, this video is not meant to be legal advice. I'm not your lawyer unless you hire me. This firm is not your law firm unless you hire us. So this video is for informational purposes only. We want to be clear about that. But I will tell you, in the cases that we handle as medical malpractice attorneys, we usually require an autopsy to be completed, because to really hone in on a cause of death for a medical malpractice case, let's say it's done, let's say you're concerned about a surgery not being completed correctly, treatment not being provided correctly. In order to actually hone in on the cause of death, usually you're going to have an autopsy be completed for that doctor to reach an opinion as to the cause of death to a reasonable degree of medical probability. That's going to be the requirement in order for them to testify in court. Oftentimes I will get folks call me. They'll say, hey, look, we have a friend who's a doctor, or the family physician, or the treating doctor that the primary care doctor from my loved one believes that this was medical malpractice, but they actually, were not actively treating the person when they died. They didn't actually investigate or treat the person to evaluate the cause of death. And certainly they didn't do the autopsy themselves, but they're speculating that it was probably medical malpractice. That's not usually going to be enough. You need a doctor to actually have hands-on understanding and hands-on forensic evaluation in order to really get to the crux of the cause of death, typically speaking. Are there exceptions? Sure, there may be, but in my view, I will also say, again, this is not legal advice, but this is informational purposes only, but in my own practice, medical malpractice cases are usually very, very expensive. When you think about the total cost to litigate a medical malpractice case versus the cost of an autopsy, it's relatively minimal cost. We're talking about 5 to 10 grand when we're talking about the whole context of a case being litigated in 6 figures sometimes. So though that is a lot of money, when you're thinking about the whole life of the actual medical malpractice case, it's a relatively small investment. And I think it's a necessary one. And the other thing is it never can really hurt to do an autopsy. Of course, now the autopsy could come back and say it wasn't medical malpractice. So there you have the doctor ruling out medical malpractice, ruling out the cause of death was what was being speculated upon. So, I mean, when you think about it that way, sure, it could, quote, hurt a case. But if the loved one did not die due to medical malpractice, then that's information that is absolutely valuable. If nothing else, it gives closure, I think, to the family. Now, of course, I'm not the one. If you're watching this video, I want to say, first of all, condolences, and my heart goes out to you and your family. But if you're watching this, you're trying to learn about this whole process. And, I'm not the one experiencing what you're experiencing. But I would like to think that if you were told by a doctor, look, it was not medical malpractice, this was just something that happens or a natural cause, that hopefully would give some sort of closure. Again, I'm not speaking on your behalf, not meaning to be presumptuous, but something to think about. In that context, I guess it could hurt a medical malpractice case. But if you don't have an autopsy demonstrating that it was malpractice, then let's be honest, it's going to be a pretty speculative claim anyway. So that's just something to think about, okay? And again, it's very difficult to prove medical malpractice cases. Ultimately, it is the family's decision about whether or not to get an autopsy. And I will tell you, just to be clear, in Virginia, bringing a medical malpractice case is very expensive. It's going to be very difficultly fought by the provider because, again, they don't want their insurance premiums to go up. They don't want their reputation to be hurt. Again, a lot of doctors, just like us all, are pretty egotistical. They don't want to be the reason somebody died. And so usually that system produces a medical doctor in support of them to say that it was not medical malpractice or that it didn't cause the death, whatever we're claiming happened here. And they will fight these cases tooth and nail. And you've got to really demonstrate, if you're going to pursue a medical malpractice case, you've got to really demonstrate that you're willing to go the full length of the battle in order, a lot of times, for these doctors as well as their insurers to actually pay fair value on these cases. And in my view, if you've not even started on the proper foundation by not getting an autopsy done, you're already behind the 8 ball here and demonstrating that you're ready to go all the way. But also, these cases rest on the medicine. These cases rest on the science. We can assume that the doctor or the other provider that you are claiming committed the malpractice is going to have their doctors and their medical providers saying this wasn't medical malpractice. You can assume that they're going to be able to find somebody to say that. So if you don't have your ducks in a row, if you didn't get that foundational requirement of an autopsy, it's just going to be a very difficult path. And again, we don't represent you. This is not attorney advice, but typically speaking, one of our red flags in a medical malpractice wrongful death claim is that no autopsy was done. That's usually a non-starter from my firm, because without that key piece of evidence and that the doctor supporting that and laying it out in their written report, but also talking to that doctor, it's just going to be a difficult uphill battle. So, look, again, I'm sorry if you're having to watch this video. I'm sorry if you've lost somebody. I'm shooting this video November 24th, 2025. It's the week of Thanksgiving. if you happen to find this now, and you're going through the difficult times through the holiday season, even worse. Look, I've lost people close to me as well. My heart goes out to you. But I always tell folks when I'm talking about what we do, medical malpractice cases, legal cases, my job is to be straightforward with folks and do my best to give the information I think is useful to them. So feel free to reach out if you've got questions or concerns. Feel free to comment below. You may disagree, and that's totally fine. You may watch this video and think, hey, James has no clue what he's talking about. Totally fine. If you have a potential case, obviously you can reach out to us, but feel free to reach out to other attorneys. At the end of the day, if you are concerned about medical malpractice having been committed, I want you to do your best to protect your rights. And the first step is calling an attorney to get somebody to take a look at your case and your family's case. So I wish you guys the best. Take care. Happy holidays and stay safe. Okay.